You're listening to Portfolio, the property law podcast from Davis Blank Furness.
Hello, and welcome to Davis Blank Furness's Property Insights podcast, the podcast where we unpack the legal complexities of property law in a way that's practical, accessible, and genuinely useful for you, our listeners. I'm Sarah Taylor. I'm a solicitor in the property litigation team at Davis Blank Furness, and I deal with all types of litigation, including possession claims and enforcement in relation to rental properties.
And I'm Roseline Adedeji, a solicitor in the commercial property team here at Davis Blank Furness. I deal with all things commercial property. That includes the acquisition, disposal, and portfolio management of commercial properties. In today's episode, we will be diving into one of the biggest changes to the rental sector in decades. The Renters' Rights Act 2025.
Yes, so this act received royal assent in October 2025. Enforcement-wise, the government's provided an implementation map which can be found on the government website. The act is planned to be enforced in 3 phases. Phase 1, which begins on the 1st of May 2026, sees, amongst other changes, the much-awaited abolition of Section 21 no-fault eviction notices, as well as the automatic replacement of assured short-hold tenancies with assured periodic tenancies. Phase 2, which is expected to begin from late 2026, although the precise date is yet to be confirmed, welcomes the introduction of the Private Rented Sector Database, or the PRS database as abbreviated. And finally, Phase 3, which is expected to go on up until 2035 to 2037, will see the introduction of the Decent Home Standard to the PRS database, ensuring that all properties listed within the PRS database meet a minimum standard of housing quality.
Absolutely. Now, the phased approach should give landlords the chance to get their affairs in order and to prepare for what's coming. And we're here to make sure that you're ready. In this episode, we'll look at what has changed, steps to take to ensure compliance, and then we'll wrap up with some practical tips to help landlords stay on the right side of the law. Before we dive into the upcoming changes, shall we start with a quick recap of what the landscape looked like before the act was passed?
Yes, absolutely. So we'll start by considering the way in which tenants actually occupy their rented properties and will continue to occupy until the act is implemented. So, at the moment, the vast majority of tenancies are assured short-hold tenancies, which are usually for fixed periods of time. So, for example, 6 months, 12 months, 2 years, etc., etc.
For those wondering what assured short-hold tenancies are, we've got you. But first, what are tenancies? Now, simply put, tenancies are legal agreements in which a property owner grants someone the right to occupy their property in return for rent payment. Going back to what ASTs are, as implied by its name, they are simply a type of tenancies, but specifically short-term residential tenancies, which in addition to other matters, allow the landlord to regain possession via certain statutory route.
Yeah, precisely. And currently, seeing as the Act doesn't take effect until this May, landlords are generally free to set the rent, and if they want to, they can rely on bidding wars in between prospective tenants to drive up the rent even further. If a landlord wants to raise the rent during the tenancy, they can rely on a rent review clause within the tenancy agreement to do this. They don't have to serve a notice.
So, as you would have gathered, AST landlords have traditionally held much of the power when it comes to key aspects of these tenancies. AST landlords have generally been free to choose who they rent to. They could advertise in a way that excluded certain groups, for example, people on benefits, families with children, or even students. Once tenants were in the property, there were also limited consequences for landlords in regards to the property's state of poor condition. Unless, of course, there was a specific regulatory breach, such as a gas safety issue, or where the local authority has served a notice. Now, there are very few sanctions for disrepair, and as a result, it's been quite common for tenants to live in subpar properties. In many cases, the property's state of disrepair only comes to light when they were raised by the tenant as a defense or as a counterclaim to a possession claim.
Yeah, and we see this quite often in litigation when we deal with possession claims. And of course, there'll be changes to the possession process itself, won't there?
That's right. At the moment, landlords have 2 routes to possession. They can either use the fault-based route in Section 8 and Schedule 2 of the Housing Act 1988, or they can use the no-fault route under Section 21 of the same Act.
And that's the way we've been used to for a long time, isn't it?
Yes, absolutely. Now, the Act is going to change a lot of that. So what can we expect to see?
So let's start with the headline reform. Section 21, no-fault evictions are gone. That means that landlords can no longer evict tenants without giving a reason. So some of our listeners will be aware that the Section 21 process has been the go-to method for landlords to evict their tenants where they cannot establish a ground for possession. For example, it's used quite frequently where a landlord wants to sell a property with vacant possession. So the tenant might have done absolutely nothing wrong, but the landlord can obviously sell the property for a lot more if it's empty.
And the Section 21 eviction notices are quite controversial, Ande, because it's a mandatory ground for possession.
Yeah, that's right. So as long as the landlord has served the notice properly and sent the tenant all of the necessary documents, the landlord is entitled to a court order for possession. There's no way for the tenant to argue out of it, so even if they've been the perfect tenant, they've paid all the rent on time and they've kept the property spotless, there's nothing they can do about it.
But now, with the Renters' Rights Act coming in, all ASTs will switch over to periodic tenancies from the 1st of May 2026, with a few exceptions, as there always are, such as long leases with terms of 21 years. Most ASTs would ordinarily be caught by the Act, and that includes whether the AST was granted before or following the Act. Now, on the 1st of May 2026, we will see most ASTs converted to assured periodic tenancies. You may have wondered what that means in practice. Well, regardless of the term that is stated on your AST, most ASTs will simply roll on from one rental period to the next. So this would usually be monthly or 28 days or less. Well, regardless of the term stated on your AST, most ASTs will simply roll on from one rental period to the next. This would usually be monthly or every 28 days or less. This all depends on how often you pay your rent. When it comes to ending the tenancy, tenants will also be able to give 2 months notice to their landlords. This is, of course, unless they agree a shorter notice with their landlords. Landlords, on the other hand, cannot rely on the Section 21 no-fault eviction notices anymore. Instead, landlords will need to cite the statutory, mandatory, or discretionary grounds for possession, which they are relying on for eviction, and also serve a Section 8 notice under the Housing Act 1988.
Now, all of the grounds for possession will be found in Schedule 2 of the Housing Act 1988. Essentially, the existing grounds for possession under Section 8 have been added to. Mandatory grounds include things like selling the property, the landlord moving in themselves, or a set amount of rent being in arrears at the date of the possession hearing. On the other hand, discretionary grounds cover issues like persistent rent arrears or breaches of the tenancy agreement.
We must flag that each ground comes with its own notice period and condition. So, for example, if a landlord seeks to sell his or her property, they will need to serve a 4-month notice. Additionally, their tenant must have occupied the property for at least 12 months. On the other end of the spectrum, landlords may successfully obtain eviction notice against their tenant with serious antisocial behavior, of course subject to conditions.
And some of the notice periods have changed for grounds that were already in existence. For grounds relating to rent arrears, the notice period has doubled from 2 weeks to 4 weeks. And it's especially important to note that the mandatory ground for possession based on rent arrears has increased from 2 months of rent arrears to 3 months of rent arrears. So, where before a landlord would serve a 2-week notice on a tenant who had accrued 2 months of rent arrears, the landlord would now need to serve a 4-week notice on a tenant who has accrued 3 months of rent arrears. Now, the next big change is rent increases themselves. Landlords can only increase the rent once per year, and they must use the process in Section 13 of the Housing Act 1988. Tenants can then challenge any increase in the first-tier tribunal. The increased rent can only commence 2 months after the date of the Section 13 notice, court determination or agreement, whichever applies. So, no more backdating of increased rents.
Yes. Now, the other big rent change pertains to properties advertised rent. Landlords will have to stick to the rent that they advertise, and this brings an end to bidding wars. So, if a property is listed at £750 per month, landlords cannot accept a penny over that £750, even where tenant offers to pay more. Naturally, this creates uncertainty on landlords' rental income and their ability to lend against this. But the positive news is that landlords can still carry out thorough pre-letting checks to make sure that a prospective tenant is financially stable. We're yet to see how lenders will respond to this, but we do expect there will be changes to pre-lending requirements for landlords.
So, what can landlords actually accept and when? So, after the tenancy agreement is signed, but before the tenancy starts, landlords will only be able to ask for a maximum of 1 month or 28 days in advance. So that would be 1 month for tenants paying monthly rent and 28 days for tenants paying their rent every 28 days or less. Landlords will also be able to request a security deposit of 5 or 6 weeks' worth of rent, depending on the property's annual rent. So, 5 weeks' worth of rent if the annual rent is less than £50,000, and 6 weeks' worth of rent if the property's annual rent is £50,000 or more. What do you think of that, Rosalyn?
I certainly think that this would make renting a property much more affordable for tenants. I expect that tenants in London would particularly welcome this change. Now, an exception to this rule applies to social housing landlords and landlords renting to local authorities for people legally considered homeless. This category of landlords may retain the ability to request a higher rent in advance.
Now, something else that might seem small but will be a hugely welcome change for a lot of tenants who have pets is that under the Act, the tenant now has a right to request a pet and a landlord cannot unreasonably refuse. There is a process to be followed, however. Landlords must respond to requests to keep a pet within 28 days, this being a decision of whether to grant or refuse the request. But if the landlord requires further information, so for example the type of pet, they must request it from the tenant within the same 28 days. And once this further information is provided by the tenant, they must then respond within 7 days of the tenant providing the required information, unless they've agreed a different date amongst themselves. If the tenant doesn't respond, landlords are not obliged to give or refuse their consent. Where the landlord is themselves under a lease, they must take reasonable steps to seek the superior landlord's consent within 28 days of the tenant's request. If the tenant finds the landlord's refusal unreasonable, they may apply to the courts for a determination. It's important to note, however, that if the pet would cause the landlord to be in breach of their own lease with a superior landlord, or if the superior landlord has refused consent despite the landlord taking all reasonable steps to procure such consent, then the landlord, under the Renters' Rights Act, may refuse to consent to the tenant keeping such a pet.
And another really important change is in regards to tenant discrimination. The days of no DSS, no children, no benefits, well, those days will soon become a thing of the past. Landlords and their agents can no longer refuse a tenant simply because of these factors. These discriminatory acts are about to become unlawful. To show how far-reaching the new act is, landlords cannot take any step that prevent these categories of tenants from, for example, viewing a property. Now, if you are a landlord, has your mind raced to your mortgage deeds, to your insurance policies yet? After all, these documents traditionally contain discriminatory provisions that allow certain types of discrimination. Well, once this section of the Act is implemented, any mortgage deed that contains such provision becomes void. Yes, void. Insurance policies that contain such discriminatory provisions will be treated slightly different, however. Now, as long as the insurance policy was in place before the Act was implemented, the insurance policy will continue to remain valid. However, once the insurance policy is renewed, those provisions, the discriminatory provisions, become void. As you would expect, there are limited exceptions. They always are, and there. For example, where a certain exclusion is genuinely necessary to meet a legitimate aim.
Okay, so landlords do still retain some discretion then?
Absolutely. So, for example, landlords can still take a tenant's benefit into account when looking at their overall income. If it's clear on the surface that the tenant wouldn't be able to afford the rent, then the landlord can rely on that as a legitimate reason to decline the tenant's application.
And finally, but very importantly, landlords must provide a written statement of tenancy terms at the start of every tenancy. This sounds obvious, but it's not always done, and failure to do so could impact possession proceedings later on down the line.
Are you feeling the heat yet?
I am.
Well, compliance is where it really starts to intensify. One of the biggest shifts is the extension of the Decent Home Standard to private rentals. Now, traditionally, the Decent Home Standard only applied to social housing. However, we expect that from 2035 to 2037, private rented properties will also need to meet certain set benchmarks for safety, repair, and energy efficiency.
Oh, that sounds serious. What does it mean in practice?
Well, the Act gives the Secretary of State wide-reaching powers to set the standard that private rental properties must meet, such as the required level of repair, the required methods to keep rented properties at suitable temperature, and what landlords would need to do to ensure the safety, security, and comfort of anyone living in these properties.
Now, you might be wondering which properties will fall under the Decent Home Standard. In short, it will apply to pretty much every home in the private rented sector and essentially all properties recorded on the PRS database. And the Act also gives the Secretary of State power to extend these standards to other types of accommodation in the future, if necessary.
Now, enforcement-wise, local authorities are empowered by the Act to inspect any property they believe may not meet Decent Home Standard, as well as properties that they've received a complaint against. Those inspections must be carried out in line with the Act, and if a property doesn't meet the required standard, the local authority can take actions. That could include improvement notices, prohibition orders, hazard of failure awareness notices, emergency remedial action, and in very serious cases, demolition orders.
Exactly, and it's not just notices. Local authorities can also issue financial penalties of up to £7,000 for certain failures. So, for example, if a property has more than one Category 1 hazard, such as severe damp or unsafe electrics. And that's not the end of it. Repeated offences can result in fines of up to £40,000, so it is really important that landlords address any issues that are raised as soon as possible.
The good news, however, is that landlords do have a right to appeal these notices. Landlords can challenge the specific notice within 28 days of receiving them. And the local authority, upon receiving such appeal, can then choose whether to withdraw the notice, reduce any penalty they set against the landlord, or simply to affirm their notice or penalty. Now, if a landlord still disagrees with the final penalty or decision, the landlord can take the matter to the first-tier tribunal.
And don't forget about RWAB's law. Landlords must fix hazards, and particularly those relating to damp and mould, promptly. If the landlord receives a complaint from the tenant about either of these issues, they need to sort it out straight away. Failure to do so could lead to enforcement action and those hefty fines that we mentioned earlier.
Now, because this section of the Act is not expected to be implemented until 2035-2037, we expect that further information and guidance will of course be provided as we get closer to the enforcement period. However, if you're a landlord, it would be sensible to begin preparing now by addressing any outstanding disrepair in your properties. This would help avoid significant remedial costs once the standards are published and formally take effect. Now, non-compliance with the standard risks fines in the thousands. Landlords can also review the publicized consultation on Decent Home Standards just for an idea of what to expect.
And there's also a new regulatory infrastructure. Landlords must register on the PRS database, and tenants will have access to a private rented sector ombudsman for dispute resolution. Landlords must respond to complaints through the ombudsman, or they may face enforcement penalties.
Enforcement is tough. This is where the local authorities come in. They have significant new powers, as we said earlier, under the Act. Now, local authorities are responsible for maintaining the PRS database, and landlords' registration on the PRS database is absolutely mandatory. Failure to register on the PRS database means you cannot legally rent out a property.
And local authorities can also impose civil penalties for non-compliance. Like with the penalties for failure to comply with hazards notices that we mentioned before, these penalties can be up to £7,000 per breach or £40,000 for repeat offences. And they apply to a range of offences, like failing to register with the PRS database, ignoring ombudsman decisions, or breaching the decent home standards. And they don't just apply to landlords. They extend to people acting on behalf of landlords, such as property or estate agents.
That's right. And it doesn't just stop there. As well as receiving multiple penalties for repeated breaches, serious offenders may face banning orders. This means orders preventing them from renting out property for years.
Plus, any enforcement measures will be recorded on a national database of offenders. If you're on that list of offenders, it's public to enforcement bodies.
This would, of course, carry real reputational risk. Now, it could seriously affect a landlord's ability to operate, and as we would expect, to obtain a loan from lenders. Rent repayment orders have also been expanded. Tenants can now reclaim up to 12 months' rent for serious breaches, such as unlawful eviction by their landlords or their landlord failing to meet the decent home standard.
So, after all that, what should landlords do to stay compliant? First of all, review your tenancy agreements. Make sure they reflect the new rules that are coming in and remove any reference to Section 21 notices or rent review clauses. Speak to your property agent or solicitor if you're not sure, and it might be worth generating an entirely new tenancy agreement to reduce the risk of including terms that refer to fixed terms, rent reviews, for example, or even a ban on pets.
Secondly, make sure to place it in your calendar to register on the PRS database as soon as it is live. Registration is absolutely necessary, as we've drummed on. Failing to register on the PRS database could mean fines or even a ban.
Third, audit your properties for decent homes compliance. Check safety, repairs, and energy efficiency now. And if you've been sitting on any complaints of disrepair made by your tenant, get those complaints checked out straight away.
Also, make sure your staff or agents are properly trained on the new anti-discrimination rules. Remember that those no DSS, no children policies are now unlawful. So take time to review your existing insurance policies, your mortgage deeds. We understand that these changes may feel daunting or confusing, but they do not have to be. Get in touch with us if you need guidance.
And finally, prepare for ombudsman complaints. Keep detailed records of everything: rent increases, repairs, communications. Good documentation will always be your best defence.
If you need detailed, tailored advice, speak to a property law specialist. At Davis Blank Furnace, we have a strong team ready to support you. So whether you need help updating your tenancy agreement, reviewing your existing property portfolio, or preparing and serving a Section 8 or Section 13 notices, get in touch with us. We're here to help you.
So all that remains to say is thank you for listening to Property Insights from Davis Blank Furnace. And if you've got any questions at all on anything we've covered today, please get in touch or visit our website at www.dbf-law.co.uk.